that we will present evidence on today. And that is that Ohio law is very clear, could not be more clear, that the circulator of a petition must be a member of the same political party as the candidates on whose behalf they are soliciting. A provision designed to stop Democrats from soliciting petitions to impact Republican candidates, or Republicans to solicit petitions for third-party candidates that would impact Democratic candidates. 35-1305 is very clear. Each separate petition paper shall, again the mandatory word shall, be circulated by a, quote, member of the same political party as, in this case, the joint candidates for governor and lieutenant governor. There has been some suggestion that that provision is an irrebuttable presumption. That means that if you are not registered for any party, no matter what your commitment to another party might be, if you're not registered as a voter in a Republican or Democratic or other primary, then you can be a member of all parties for purposes of this statute. Well, the law is clear. This is a presumption. And how do we know that this is a presumption? We heard yesterday that there's no law that determines this to be a presumption. Well, actually, that's wrong. Because if you will look at page 8 and 9 of our brief, you will see that no less a court than the Sixth Circuit Court of Appeals for the United States has said that words almost identical to the statutory language that is involved here were held to be a rebuttable presumption. And just in case there's any question about federal law being different than state law, you will see that the same language, the language that shall be considered, is a rebuttable presumption, has also been held in the Wolf case by the 8th District Court of Appeals. And as such, the legal issue of whether or not the presumption is rebuttable, we believe, is subject to controlling law. The Supreme Court has said where the presumption is not indicated to be irrebuttable, it is in fact rebuttable. What difference does that make in this case? Well, to start with, if you have to be a member of the same party as the Libertarian candidates under this statute, as we believe, then all of Sarah Hart's petitions that she circulated, again totaling 241 signatures, have to be excluded because Sarah Hart is not a member of the Libertarian Party. Indeed, the evidence will show that just 3 months prior to the time she signed a statement under penalty of election falsification that she was a member of the Libertarian Party, she filed a statement with the Cuyahoga County Board of Elections indicating, at I believe Exhibit P20, indicating that she was in fact a member of the Democratic Party, showing a Democratic Party affiliation there in the middle of the page on Exhibit P20. And you'll note under the little box at the bottom that Sarah Hart not only said she was a member of the Democratic Party, she said so under penalty of perjury. So 3 months before she solicits the petition, she is declaring under penalty of perjury she's a Democrat, and then she signs the petition saying she is not a Democrat, that she is a member of the Libertarian Party. It is clear, we believe, that the sworn statement under penalty of perjury invalidates any suggestion she is a member of the Libertarian Party. We would have liked to have Sarah Hart here, but as another exhibit shows, Ms. Hart has left the state, was not subject to the subpoena power, and thus we will not be able to produce her for testimony today. But we have included a number of exhibits that show she is a paid professional circulator. We have included Exhibit 20, which shows that she swore under penalty of perjury that she is a Democrat, and we believe that that rebuts the presumption contained in the statute, and therefore it will take affirmative evidence from Sarah Hart and or the Libertarian candidates to overcome the evidence of exhibit number P20. So again, Sarah Hart's petition should be excluded for a second reason. But there is more.